will be included as an exhibit in the official hearing record. When you come up to testify, please speak clearly into the microphone. Tell us your name and spell your first and last name to ensure we get an accurate record. We will begin each bill hearing today with the introducer's opening statement, followed by proponents of the bill, then opponents, and finally by anyone speaking in the neutral capacity. We will finish with a closing statement by the introducer if they wish to give one. We will be using a 5-minute light system for all testifiers. When you begin your testimony, the light on the table will be green. When the yellow light comes on, you have 1 minute remaining, and the red light indicates you need to wrap up your final thought and stop. Questions from the committee may follow. Also, committee members may come and go during the hearing. This has nothing to do with bills being introduced. Final items, they'll take hearing. If you have handouts or copies of your testimony, please bring up at least 10 copies and give them to the page. Please silence or turn off your cell phones. Verbal outbursts or applause are not permitted in the room. Such behavior may be cause for you to be asked to leave the hearing. Finally, committee procedures for all committees states that written position letters to be included in the record must be submitted by 12 noon, the last business day before the scheduled hearing on that particular bill. The only acceptable method of submission is via the legislature's website at nebraskalegislature.gov. You may submit a written letter for the record or testify in person at the hearing, not both. Written position letters will be included in the official hearing record, but only those testifying in person before the committee will be included on the committee statements. I will now have the committee members with us today introduce themselves, starting on my far left.
Thank you, Chair Bosselman. Good afternoon. My name is John Frederickson. I represent District 20, which is in central West Omaha.
Julie Slama, District 1, Richardson, Pawnee, Johnson, Nemaha, Noto counties.
Jana Hughes, District 24, Seward, York, Polk, and a little bit of Butler County.
My far right.
Tom Brandt, District 32, Fillmore Thayer, Jefferson, Salina, and southwestern Lancaster counties.
Mike Jacobson, District 42, Hooker, Thomas, McPherson, Logan, Lincoln, and 3/4 of Perkins County.
John Kavanaugh, District 9, Midtown Omaha.
Mike Moser, District 22, Platte County, and most of Stanton County.
Senator Moser also serves as the vice chair of this committee. Also assisting the committee today to my left is our legal counsel, Cindy Lamb. To my far right is our committee clerk, Lori Bollertson. Our pages for the committee this afternoon are Trent Kadabi and Landon Sundi. Thank you very much for being here this afternoon and assisting us. With that, we'll begin today's hearing with LB 725. Welcome, Senator Dungan.
Thank you. Good afternoon, Chair Bostelman and members of the Natural Resources Committee. I'm Senator George Dungan, Georgedungan. I represent the people of Northeast Lincoln in Legislative District 26, and today I'm going to be introducing LB 725. Legislative Bill 725 is a bill to prohibit the use of ratepayer funds from being used for or against a political candidate or ballot question. LB 725 clarifies that public resources may not be used for the purposes of contributing to a campaign committee, even if they first pass through a membership organization or cooperative. The principle is simple. Taxpayer or ratepayer dollars should not be used to advocate for or against a candidate for office. Nebraska has a proud tradition of public power, and the use of this money in public power districts to contribute to political campaigns is not only a betrayal of that tradition, but it's a betrayal of public trust. As you may have noticed, I did hand out AM 586 for your review. That is a white copy amendment, so you can refer directly to that. The amendment addresses a couple of issues. First of all, it's much shorter and a little bit easier to read. So that was, I think, a form issue we had them address. Second of all, the bill as it's currently written before the amendment, any person who violates the section shall be guilty of a Class 3 misdemeanor. AM 586 changes that potential penalty to a civil penalty not to exceed $5,000. The reason for that change, among a couple of different reasons, was one, I think it's clearer. I think that it becomes somewhat problematic when an entity is donating money and then a criminal charge gets placed against that entity. I don't know who actually would get charged with that, whether it's the secretary or the treasurer. So we thought a civil penalty made more sense for that. In addition to that, It ensures that any fees or fines associated with violating this section cannot be paid for using ratepayer proceeds. AM 586 better defines who this applies to. I do want to make very clear that my office has been in communication with stakeholders, including the Power Review Board, NPPD, a number of other individuals. I've spoken with representatives from co-ops, and so we have been made aware of some of the issues that people have with that. We look forward to working with folks in the industry to ensure that we're not causing any undue harm. As I said, at the end of the day, the crux of the issue here is ensuring that public money is not used or utilized for campaign donations. Thank you for your time and consideration. I'm happy to answer any questions, and I would urge your consideration of LB 725.
Thank you for your opening. Other questions, committee members? Senator Frederickson.
Thank you, Chair Bossman. Thank you, Senator Dungan, for bringing this bill. I agree with this premises. I think that public funds are certainly, it seems to be a conflict of interest, or I don't know if conflict of interest is the right word, not something we're wanting to be campaigning on. I am curious, I don't know if you saw there were some letters that were submitted. There was one letter of opposition submitted from the Nebraska Electric Generation and Transmission Cooperative. They kind of highlight that this is, it says LB 725 only applies to ratepayers of electric service and not ratepayers of gas, water, or propane. It says obviously subjective toward the electric industry and not based on fairness, equity, or common sense. I find that to be sort of like a bit of a difficult argument because it's not arguing the principle of the bill per se, but it's kind of saying that they're being targeted. I just wanted to kind of get your thoughts on that, or if you had any, if you could speak that a little bit, that'd be helpful.
Yeah, I mean, I certainly think that, it's my bill, so I might be a little bit biased, but I absolutely think it's based on common sense, when the common sense principle here is that captive audiences who are ratepayers shouldn't have their money ultimately be funneled through to candidates or campaigns that they don't support. I think that's the fundamental predicate of this bill, is we just want to make sure that folks who are paying money to a rural power district, that subsequently that money as a ratepayer proceed goes to a co-op, for example, that it's not ultimately being utilized for those campaign proceeds. As to whether or not it should apply to other ratepayers outside of electricity, I'd be open to having that conversation as well. This bill is not the beginning of a conversation. It's a conversation that's been going on for a while. I'm new to that conversation, but I know there's been specific instances, I think specifically talking about some of the allegations or concerns folks have had against NEGT that you're just talking about, where there were concerns that maybe those funds were ultimately going towards political candidates from captive audiences. And so I guess I don't share their concern that it's not based on common sense. I think it is common sense to make sure that ratepayers' money is not being used for that purpose. But as to whether or not this is too narrow of a restriction and they'd like to see it apply to other things, I would absolutely be happy to have that conversation.
Thank you.
Other questions? Senator Brandt.
Thank you, Chair Bossman. Thank you, Senator Dungan, for bringing this bill. So what inspired you to bring this? Is there a lot of incidences in Nebraska of this happening?
That's a good question. I think some of the testifiers after me might have a little bit more personal history with this. I know, for example, actually, let me take a step back and say, I want to be very clear to the committee as well as folks in the room. I don't think this is a widespread problem, right? I don't believe we have a lot of bad actors out there. I don't believe we have a lot of individuals who are trying to utilize ratepayer proceeds in order to donate to campaigns, but I do believe there are circumstances where that has happened. I just mentioned leading up to the 2020 election, we know for a fact that Nebraska Generation and Transmission Cooperative donated at least $7,500, and that's what we know. They loaned that money rather, and that's what we know. And I think there were other concerns about additional money being used, and there were NADC complaints that were filed. So we do have documented evidence that this has happened. And again, I don't believe that all of our rural co-ops and places like that are doing this. I don't think that LES or other places are doing this necessarily. This bill simply seeks to enshrine a protection for ratepayers who, as I said, are essentially captive audiences, to make sure their proceeds are not subsequently being funneled through to other entities or organizations that then use it for political gain.
So in your research, are a lot of these funds going toward candidates for those electric utilities, or they're contributing funds to national races? What is your research showing?
That's a good question. I don't have specific. I can get the specifics for you pretty quickly on that. I don't know for a fact if they're going to national races. I believe they're going more to local races is what my research has shown, and other committees and major issues they're donating towards. But I can definitely get you information pertaining to who it directly was going to.
All right, thank you.
Senator Jacobson.
Thank you, Chairman Bosselman. Senator Dungan, thank you for being here, and nice to have you in our committee. I think the first time for you here. Maybe.
It is.
All right.
Happy to be here.
Well, great to have you. So I guess a little bit of follow-up on Senator Frederickson's question, why you've limited it to just electrical utilities and why we aren't just doing a blanket if this is good, if it's good for the goose, maybe the gander as well. And are we not just looking at a blanket issue, or is this just because you're aware of some specific issues at a particular electric rate supplier? I'm just.
Yeah, no, that's, I think, a very good question. And I appreciate that, as well as Senator Frederickson's point. This is not personal for me. Like I said, there's some other individuals out there who I think this has maybe affected more, who this conversation started back in 2019, 2020 around that. For me, it's a good governance issue. For me, this is not necessarily left or right or even political. It just makes sense to me when I spoke to individuals about protecting ratepayer proceeds from going to political campaigns. Again, I would be more than happy to talk about whether that can apply to other utilities as well. I think what makes this a particularly interesting and unique situation is we're a public power state. And when you have a public power state that uses these rural public power districts, you subsequently use those ratepayer proceeds to pay membership dues, for example, to co-ops. I think that is a unique situation that we don't see necessarily with regard to other utilities. If we're talking about water, gas, the structure and the infrastructure for how those payments get processed and sort of whether it's private or public is just slightly different. Because we are a public power state, I think that is sort of the impetus for having this conversation, is because we utilize that public power. And as I've talked about, we have these captive audiences. I think that's why this legislation focuses on that. But I'd be more than happy to talk about other utilities and what they seek to do. What I don't want to do, and what I understand some opponents to this may think I'm doing, is I don't want to limit ability their money is like a private company. We say can't do X. Is we're talking about their public per the sole income source for these co-ops. And so I think when you start talking about organizations like the co-ops or other individuals, I think we do have the ability to govern a little bit more what they do or don't do with those proceeds, because it's public power proceeds. And again, these are captive audiences. So I think it's slightly different than telling a private company what to do, given the revenue source that they are based off of, if that makes sense.
Yeah, it does, and thank you. And I must have missed out that was one of the potential sources. I missed it in my campaign, but thank you.
Chair Hughes.
Next time.
Thank you, Chairman. It's George Day today, so thanks for coming in, Senator Dungan. Okay, so there was an Attorney General opinion, and I'm guessing you probably saw it, April 9th, 2021, that in it says, we conclude that an electric cooperative corporation is a private nonprofit corporation and not a governmental entity. As a corporation is an entity that is authorized by the Nebraska revenue statutes, numbers and that weird little symbol, to make contributions and expenditures as those terms are defined in the Nebraska Political Accountability and Disclosure Act. So there's no language within the NPADA that would accept, make an exception for electric cooperative corporation. So with that being said, and let's say this bill would go through, wouldn't it end up getting challenged in the courts?
I mean, I absolutely think there would be a challenge to that to a certain extent. I think there's a differing of opinions on this. And again, I like to go back to what the overall purpose and point is, right? To me, this is different than telling a company what they can and can't do, given the fact that the sole income source or the sole revenue source for their proceeds are from ratepayers. And so even if the organization that we're talking about here that's organized under Chapter 70 is not in and of itself a public power entity, I believe that because the money they're using to then later on support political campaigns or committees or things such as that come specifically and solely, at least it sounds like, based on what I've been able to find out, from ratepayer proceeds, that's the problem. And so I would simply disagree that they can be treated just as private companies. But I don't get into the business of telling private companies in general what they can and can't do with their money. But because that money comes from ratepayers and that's it, I think it's slightly different and needs to be handled differently.
Okay,
Thank you.
Sir Mosier.
So the large utilities all have elected boards, right? So they have to run for office. So if they do something wrong, a candidate could make an issue of it in a campaign and use that to run against a board member. Is that a check and balance for what you're worried about here?
I think that's one.
And then the cooperatives. Uh,
people can and can't do. But my issue with it, I think a lot of times is transparency. And I think you'll hear some conversation with my next bill. As Senator Hughes pointed out, it's George Day, so I'll be testifying on another bill, what isn't happening. And I think that we all have been made aware of this issue. This is because a few people paid attention and then talked about it. And so I don't think it's the kind of thing that's going to be widely acknowledged or widely known. Becoming again, bad actors utilize these ratepayer proceeds in a problematic way, and I want to try to prohibit that and stop that at the beginning.
Okay, thank you. I got a question for Senator Jacobson. Is it McPherson or McPherson? County.
Any other questions? Any other questions? You stick around,
Yes.
obviously, for closing.
Yes.
Okay.
Thank you.
Thank you. Thank you for your proponents, please. Anyone like to testify in support of LB 725, please step forward. Good afternoon. Welcome.
Good afternoon. My name is, good afternoon to Chairman Bostelman and committee members. My name is Kate High. I live in Lincoln. However, for most of my life, I lived in rural Nebraska and was a customer.
Spell your name, please.
Oh, excuse me, Katehigh.
Thank you.
I was a customer and a ratepayer of the Elkhorn Rural Public Power District in Battle Creek. And I'm here today in support of 725 and 726. You'll notice that on the sheet. I have, first off, 2 points. Money paid to public power districts by ratepayers for their electric service is, by definition, public money. LB 725 clarifies that when public ratepayer money is transferred from a local public power district to an electric co-op, it remains public money. Number 2, it is contrary to Nebraska law for public money to be used for political purposes. Public money, even when it is in the form of a loan, cannot be used for campaign contributions. In 2020, I complained to the Nebraska Accountability and Disclosure Commission, the NADC, that public ratepayer money that had been transferred to an electric cooperative, the Nebraska Electric Generation and Transmission, NEGT, was used for political purposes. Public money that came from ratepayers was used to make a $7,500 loan to a newly created political action committee, a PAC, called Nebraskans for Reliable and Affordable Energy, NREG. The PAC used the interest-free loan to make campaign contributions. I lost the complaint. The reason, according to Darren Bloomquist, Executive Director of the NEGT Electric Co-op and a founder of the NREG PAC, was that once public ratepayer money was transferred to the electric co-op, it was no longer public money and could be used to make campaign donations, and in Mr. Bloomquist's words, was no different than buying a truck tire. Most Nebraskans, particularly us rural folks, are able to discern the difference between a truck tire and a campaign donation, even if Mr. Bloomquist cannot. Let's keep it real. Ratepayer money that has been transferred into a NEGT co-op bank account remains under the control of rural public power districts that make up the membership of NEGT. The same cannot be said about truck tires. Ratepayers were left in the dark about the political activity of the electric co-op and how public monies were being spent. Who knew flipping a light switch was the new way to make a campaign donation? Current law exempts all cooperatives from open meetings laws. And I'll be talking about that. LB 26 would require both co-ops and public power districts to provide information on their websites that would improve transparency and accountability. Public power districts and NEGT were both publicly created. Public officials govern both, and both are publicly funded. Public money requires public regulation with full public disclosure. To me, this is fundamental to good governance and accountability. The Attorney General's opinion, which was requested by the NADC in regard to my complaint, was not clear-cut. The Attorney General determined there was no legal restriction against cooperatives in general making campaign donations, but the issue was left dangling in regard to electric co-ops. The provision of law the AG cited as creating the uncertainty was 70-704, number 17. And I have a quote here. And the section 70-704 is actually 17 reasons there. And they say 17 is the one that, number 17 is the one that stands out. And it would lead out, each corporation shall have the power, and then number 17, to have and exercise any and all powers as may be necessary, convenient, or appropriate to effectuate the purpose for which the corporation is organized. The issue for electric co-ops remains unsettled. Are no interest loans for campaign contributions a wise, necessary, and appropriate use of revenue? Is this the best use of ratepayer money? George Norris would be very disappointed to see these ill-considered attempts to politicize our public power system. NEGT has established a legally and ethically shaky precedent. If it would stick to buying tires, we wouldn't be meeting here today under these circumstances. So the committee can do something right here, right now to fix this. And I ask your support for both bills. Thank you.
Thank you for your testimony. Are there any questions from committee members? Sir Kavanaugh.
Thank you, Chairman Bossman. Thank you for being here, Ms. High. So you were a ratepayer in the Elkhorn Public Power District?
Elkhorn Rural Public Power District. And I just want to add this to this. I was also on the school board, and I also paid the school board's electric bill. And I realized that a portion of that electric bill that was from the school bill was actually ending up a campaign contribution, because that public money stays public through this entire process. There's no way that you can shake a wand and make it less public.
Well, I appreciate that, but I'll get back to my question. So you were a member of the Elkhorn Public Power District. How did you come to choose Elkhorn Public Power?
It's a monopoly. I don't have a choice. It's not like I can say, well, I don't like the Elkhorn Rural Public Power and I can get my electricity someplace else. It's a monopoly.
So it was by virtue of where you lived.
Right.
You had to have Elkhorn.
Madison County.
Okay. Did you have any say in who was on the board of the power district there?
Yes, we got a district representative.
Was that by district? Was that by?
Yes, that's how I think so. At the time I made the complaint, it was I have a copy that Mr. Zwoner, I believe, that was the representative, and they're on the ballot. I think we vote for those.
Okay. And you said now you moved out of Elkhorn or out,
Yes.
sorry, out of Battle Creek.
I live in Lincoln now. Yeah, no, I didn't live in Battle Creek. I lived on a farm in Madison County.
Okay. I wrote down Battle Creek, I guess. And so you moved out of the district, so that's how you got out of having to buy power from them.
Right. So now it's Lincoln Electric System.
Lincoln Electric System.
I don't have a choice here in Lincoln either.
That was going to be my next. Thank you.
Any other questions? Seeing none, thank you
All
for
right.
coming in today.
Do we need to come back for 726?
You would need to come back for
Yeah, if I
726.
wanted to. So I kind of, okay, you'll hear it twice then.
Next proponent.
Good afternoon, Senator Bosman, members of the Natural Resources Committee. I'm Al Davis with the Nebraska chapter of Sierra Club, and just wanted to clarify, Senator Moser, I'm here in favor of a bill today. Took your advice yesterday. I thought Ms. Height really explained the situation very nicely, and I'm not sure that I have a whole lot more to contribute to that. I'm also testifying here on behalf of John Hanson, who's away on Farmers Union business today. But I think that the way that I want to sort of put this together is to talk about the beef checkoff. Now you can say, how does the beef checkoff tie in with this? So the beef checkoff was put in place many years ago, requires every cattle producer to pay money into a fund. The process is supposed to promote the industry. What has happened with the beef checkoff is there has been commingling of money on the political side and the promotion side. And so that has resulted in a tremendous amount of dissatisfaction with cattle producers who don't feel that they are heard and don't want their money used to promote some of the things that the National Cattlemen's Beef Association is promoting. So you say, how does this connect with this? Well, that's what's known as government speech. So in some respects, I think what we have here is the same thing. We've got ratepayers who have no ability to get out of an arrangement with the public power entity. They have to pay their rates to the entity. The entity then pays dues to another organization, and ultimately ratepayer dollars transmute through the system and come out in the form of political contributions. So from my perspective, I think that's very destructive for the entity itself and for public power to go down that road, because I don't think that's a good use of their resources. They need to take the money that they have, use that in the business in which they are engaged. If they want to make private contributions, then solicit money from the managers, which I think has been done in the past, to promote a cause. But when you use ratepayer dollars, you're just really getting into dangerous territory. I think that there was a question, I think it was Senator Jacobson asked a question about gas companies and those entities like that. And I just would remind you that only in Nebraska are these people elected because of our public power status. So I think that gives the government a little more urgency in trying to control this to prevent sort of the image of a tainted election. So I think that's about all I have to say. You can read my testimony also if you'd like to.
Okay, thank you for your testimony. Committee members' questions, Senator Brandt?
Thank you, Chair Bosman. Thank you, Senator Davis, for appearing today. In the case of the beef board, the courts ruled that they could not use that money for campaign contributions. Isn't that right?
Yes.
Yeah. And so subsequently what happened was the associations were the ones that have to raise funds if they want to do something on behalf of beef. But those checkoff dollars, because you used the comparison, that was the same as the ratepayer, because it was government speech, could not be used for that.
Is not supposed to be used for that.
Okay.
You know, there have been audits over the course of the years that demonstrated that it was used improperly. And then the policy side had to pay back the checkoff side.
Right. Okay. Thank you.
But I just thought it was a good analogy. As I was sitting here listening, I thought, well, I'm just going to kind of bring this up because I think you can understand that people who are dissatisfied with essentially some of the policy that NCBA promotes certainly don't want to support that policy. And I think you can say the same thing with this, because ratepayers are captive. There's no way out.
Sure. Sir Jacobson?
Thank you, Chairman Bostelman. I bet you probably already knew, being up in that neck of the woods, that James Birdseye McPherson that's what McPherson County was named after.
Good for you.
I bet you knew that. So, career Army officer and Union Army officer. So, you wanted to know that. I guess digging in a little bit on I get the bill's intent when it comes back to electing an individual, but I guess I'm kind of wondering as I dig into this more, okay, you can't transfer money in some way. So I start thinking about, and this can't influence elections of any way, initiatives and so on. So I get a little concerned about if a cooperative, electric cooperative goes out and wants to support something as a part of advertising. And then it ends up on a stock car that happens to also have a political candidate's name on it. Or, in other words, how pure does this have to be? In other words, I get that you don't want to go out, and if there's something that would significantly impact this cooperative that's out there and doing some advertising to set the record straight as to what the initiative might be, or the position of that, and let's just take NPPD as an example, or someone like that. Where are those limitations, I guess? Where would you see those? with
Well, I mean,
bill?
in this case, this was an out and out legal contribution. That was
Language
I think
bill.
that's been a great some different situation. I can see that happen. Sort of serendipitously, those kind of things can happen, and there are people always out there who are looking for those problems. So you'd have to take that back to and say, well, you need to correct this situation, but this is a statewide issue, not just a regional one.
Well, probably, I'm just giving Senator Dungan a chance in his close to kind of work through that, but I'm just concerned about the unintended consequences. Plus, I'm still a little upset that I didn't know about this loophole, so I just thought I'd raise that again.
I didn't know about it either.
Yeah, so at any rate, well, thank you for your testimony, and thank you for your support of James McPherson.
Thank you.
Seeing no other questions, thank you for your
Thank you.
testimony. Next proponent, please. Anyone else like to testify in support of LB 725? Anyone like to testify in opposition to LB 725? Good afternoon.
Good afternoon, Chairman Bostelman, members of the committee. My name is John McClure, John MC capital CLURE. I'm Executive Vice President for External Affairs for Nebraska Public Power District and also its General Counsel. I'm here today testifying in opposition to LB 725. I'm also speaking for the Nebraska Power Association, which is comprised of the municipal electric systems, public power districts, electric cooperatives, and joint action agency providing electric service at wholesale and retail in the state of Nebraska. I have not had the opportunity to see the proposed amendment, so I'm here testifying on the bill as introduced. I did appreciate that Senator Dungan said this is not a widespread issue, and I really want to add some significant context to that comment. Municipal utilities and public power districts, which comprise the overwhelming majority of electric utility providers in the state, are already statutorily prohibited from engaging in election activities with very limited exceptions. I would point to section 4914-101.02, which states in relevant part, a public official or public employee shall not use or authorize the use of public resources, and that includes personnel, property, or funds of a public entity, for the purpose of campaigning for or against the nomination or election of a candidate or the qualification, passage, or defeat of a ballot question. So most of us are already very strictly prohibited under state law. I mentioned there's a very narrow exception, and that is in subpart 4 of the statute, which provides in relevant part that a public corporation organized under Chapter 70, which would be a public power district, is not banned from otherwise supporting or opposing a ballot question concerning the sale or purchase of its assets. So there's a very narrow exception, but certainly for candidates, it's a complete prohibition. Now, again, I'm working off the bill as introduced. We've heard a lot of conversation so far about cooperatives, but this applies to all of public power. So it's redundant on the one hand of what already exists in the Accountability Act. And I possibly Senator Dungan has addressed this, but the definition of ratepayer proceeds is highly problematic. Ratepayer proceeds pay the salary of all the employees of a public power district. So by the words of this statute, I couldn't make a campaign contribution to anyone by the language that's in here. A board member who is compensated for a public power district couldn't take anything they received as their compensation and put that into their campaign or the campaign of another. So that is troublesome. I can't imagine that was really the intent. That really hits the key things that are a concern. I will certainly be interested in seeing the amendment, but as written, we do not believe this is good policy. We believe it's duplication of prohibition that already exists for the majority, overwhelming majority of the industry. And I would be happy to answer any questions you may have.
Thank you for your testimony. Questions from committee members? Senator Slomo.
Thank you, Mr. Chairman, and thank you very much for being here. I appreciated your comments about ratepayer proceeds. Under this definition, do you foresee ratepayer proceeds including all employee salaries, reimbursements, all employees for public power in the state, this applying to them?
Yes, as I read the definition of ratepayer proceeds, it's very broad. Those proceeds that come from our customers pay all our expenses, and expenses include the salaries and benefits of employees.
And the courts have traditionally held almost across the board that individuals are free to donate to campaigns as they see fit, especially in the state of Nebraska, right?
Yes. Again, we have very express prohibition for public officials, public employees, what they can do with public assets. But once those have been paid to the individual, they're their own dollars to do with what they choose.
Absolutely. And just to drive this point home, how many employees does Nebraska Public Power District have?
We're at approximately 2,000.
Okay. And 2,000 employees plus whatever employees have retired, left the district for whatever reason, that would apply to them, correct?
It would not apply to them because our retirement plan is a 401k and a 457. So it's not a pension. It's not coming from NPPD assets.
However, if they were using payment they had received during their time for employment in MPPD, that would apply
Sure,
to them
if that
too.
was in a savings account, yes.
Thank you very much. I appreciate that.
Thank you.
Sir Mosier.
Do you know how that case came out, where they made a $7,500 loan to somebody's campaign?
I was not involved in that, and I don't feel like I'm qualified to speak to it.
Thank you.
Sir Kavanaugh.
Thank you, Mr. McClure, for being here. Just trying to compare the two sections about the ratepayer proceeds. I think that your reading in the green copy is probably closer to accurate, but I would say the white copy probably solves it. And I can just read you the section here where it says a district corporation shall not use any ratepayer proceeds for the purpose of campaigning against or for or seeking in any way to influence the nomination or election of a candidate for elected office. And then it shall include transferring money for the purpose of for the purpose of campaigning for, against, or seeking in any way to influence. Do you think that would catch up? If you're paying somebody the regular salary, you think that would be characterized as for the purpose of campaigning?
Depends on what they're dedicating their salary to. A board member might say, I'm going to use all my salary for the next year for campaign purposes.
Right. They're deciding what to do with it. But I'm saying the NPPD, when you pay the board members, are you paying them for the purpose of them using it for campaigning?
No, paying them for their services.
Right. And when you pay your employees, you pay an electrician, you're paying them for the services rendered, not for the
Correct.
purposes of campaigning.
Correct.
So that maybe is too broad of a reading of that paragraph. I'm talking about the new paragraph, the old paragraph. I think you maybe, and you, in fairness to you, you don't have a new paragraph.
Right. I'd like, it sounds like there's been an effort to narrow it. But again, I'd like to study the words to understand what's there clearly. All I have is the original bill, and it's extremely broad.
I appreciate your, I guess is discretion the right word? Maybe it's your reserved judgment on that. So I guess my question though is, and it seems to me like that, that's a technical problem that I think maybe is fixable, and you can clarify that language. And maybe doesn't quite go far enough, but I think it gets further than what you were talking about. But fundamentally, the question here is do you think it would be appropriate for the elected board members of NPPD to vote to direct some of the funds of the NPD organization to an organization that's explicitly for purposes of campaigning?
I think that would be clearly prohibited under existing law under the Accountability Act.
Well, I guess, but you're saying it's already prohibited for NPPD. It's not prohibited for some of these other organizations.
Well, electric cooperatives, it was noted earlier, are not public entities subject to the Accountability Act.
So, and I guess my question is, and you can feel free not to answer this one because it could get you in trouble, but I'm not asking whether it's legal or not. I'm asking whether it's appropriate that they would be directing ratepayer funds to an external organization that then could make contributions in their own election.
I'll speak for NPPD only as their general counsel. I would be concerned if that was what NPPD was doing.
Thank you.
How would this apply to someone who's net metering?
I'm going to have to think about that one.
Because they're not only selling to, but then you're purchasing from.
Because they're getting
so-
paid. Are you saying if they're receiving?
Well, in the new language, it talks about electric supplier partnerships. So, okay, that's fine.
Let me think about that one.
That's fine. But then, Sir Brandt.
Thank you, Chair Bosselman. Thank you, Mr. McClure. So the current law expressly prohibits the organization from giving directly to a campaign. NPPD could not write a check for $7,500 to the Brantford Legislature.
Correct.
NPPD, after the board meeting is over, the board members, somebody maybe wanted to donate to my campaign, could poll the other board members if they'd all like to kick in $100 each to give to the Brantford Legislature campaign. That would be legal.
Yes, if again, individual personal contributions, except as the bill is originally drafted, if those board members, they said, well, this came out of my, whatever fund, it didn't come from my NPPD paycheck because it's drafted, that would be a problem. That's originally drafted.
All right, thank you for the clarification.
What about if you have a PPA with a generator?
Again, all of our, there's two different situations. You could have a PPA. We have PPAs with private utilities. We also have PPAs with public power. So if we send a check off to OPPD for purchases we make from Nebraska City 2, those proceeds have left us, but they're in the hands of a public power entity being used to pay the expenses of that resource that we were provided. So I don't think they could do anything with it. On the other hand, if we send it to Acme PPA, let's say, it's a private entity, an LLC. I believe once it's in their hands, they're a private entity. They can do with it what they want.
So if they're supplying you energy or you're paying for the energy, you're buying energy from you or they're supplying it to you, it wouldn't make a difference.
I think they would have the free, but I need to look at this to see
That's
if
fine.
we think we can control what a private entity does. I think there was testimony from the introducer that you can't ultimately control what a private entity does with proceeds.
Understand. And once later, once you see the amendment, there, maybe we can discuss that. So,
Okay.
Thank you. Any other questions, Mr. Jacobson?
Thank you, Chairman Bostelman. I guess one quick thing, and as I've kind of parsed some of the words here a little bit, I'm kind of coming back again. You're in election cycle and you've got board members, and there's board members up for election, let's say. And all of a sudden there's an ad from NPPD with your board members' pictures out there. Okay, can that be construed as campaigning for, or I guess?
We would be, we've never had an ad with our board members in it. And we would be, I think, even more sensitive during an election cycle on how anything like that could be perceived. There was a Supreme Court case several years ago involving another public power district where there was a significant amount of radio advertising that took place, and it was perceived that it was trying to impact the board race because of topics.
Things like Peter is affected by this. The very thing you looked at, a board member's on TV talking the utility, and it happens to be in the middle of election cycle, and maybe it's an ad, so it's paid for by whatever that utility is, and where does that fit? That I was worried about collateral, why it gets so important to tightly write, and of course I'm not an attorney, but I there's times I think I am. And which is a little bit less than right now. Senator Slama hasn't gotten her results back yet, so I'm still not up to her speed. And Senator Kavanaugh has his, so I'm not gonna. So that's the standard I'm working against. But I always like to work at those individual pieces and figure out what are we missing here. So
again, with the Accountability Act as a public power district, I can assure you we would err on the side of caution, that no one would say you're trying to influence the outcome or election or a ballot issue unless that ballot issue was something very intentional that involved sale or purchase of assets.
Sure. Yeah. Thank you.
How many members are there in NPA about?
Well, we claim the entire electric industry in the state, which is approximately 160 utilities. It's about 120 distribution municipal utilities. There's approximately 30 public power districts, and then a dozen or so electric cooperatives.
Okay. Mr. Kavanaugh.
Thank you, Chairman. Thanks again for being here, Mr. McClure. So on NPA, do you pay a membership fee for that?
Yes.
And what do you get for that membership fee?
It's an organization that is member driven, and so we have a part-time staff person who's in this industry. Our administrator is Shelley Salings-Art, who you all know, but she helps, I'll say, herd the cats. But we have a board, and there's the way the bylaws are set up. There are different board members elected from different stakeholder groups within the NPA, and we work to do the voter capability report. We work to be aligned on legislative policy and deal with other issues to try to provide information collectively about the electric industry in Nebraska.
Who do you provide that information to?
It's on our website. We've started again a conference. There was a conference last August that I hope some of you were able to attend. And we'd like to continue doing that. And we try to organize other briefings from time to time to, provide information about our industry.
But none of the money that goes through the NPA then gets put into political campaigns or PACs.
No. We've had discussions as to whether we would ever want to create a PAC, and we've never gone down that route.
And when you have that discussion, do you discuss using the user fees from NPA as the funds for that PAC?
It would be separately raised, but we never got into details. We just decided not to do it.
Thank you.
Other questions? Seeing none, thank you for your testimony.
Thank you.
Next opponent to LB 725.
Good afternoon,
Good afternoon.
Chairman Bosselman, committee members. My name is James Dukeshire, James Dukesherer. I am the Director of Government Relations for the Nebraska Rural Electric Association. The NREA represents 34 public power districts and electric cooperatives throughout the state. We're here today in opposition to 725, and I'll add that I have not seen the amendment yet, so I am also speaking to the green copy. In general, LB 725 aims to block the ability of our state's public power electric utilities from using consumer dollars for campaign activities. The bill has two sections, one addressing public power districts and one addressing the electric cooperatives. First, to focus on the public power districts districts are already precluded from the acts addressed in LB 725, as was stated earlier. The Nebraska Political Accountability and Disclosure Act 49-14 stipulates that public employees shall not use or authorize the use of public resources for the purpose of campaigning for or against the nomination or election of a candidate or the qualification, passage, or defeat of a ballot question. LB 725 introduces broad new language that goes far beyond the existing statutes. The bill defines ratepayers, what we typically think of as a person that pays their electric bill, to include wholesale companies, among many others. Under the bill, an employee of a power district will be prohibited from using their paycheck to make a contribution to a candidate of their choosing. And I think we could argue that the language in the bill goes far beyond that. For example, the definitions of the language in the bill that impact any person or the use of any money. We can get into that if there's questions. LB 725 says a recipient of ratepayer proceeds shall not use such proceeds for the passage or defeat of a ballot question. As was stated earlier, Accountability and Disclosure Act includes an exemption for public power districts that would allow a PPD to engage on a ballot question concerning the sale or purchase of its own assets. It's true that Nebraska is served 100% by public power. We are the only all public power state. We do not have any for-profit electric utilities in our state. However, we do have electric cooperatives that are private, not-for-profit corporations. They're not political subdivisions of the state, and they're impacted in this bill. LB 725 would say that a private corporation formed under the Electric Cooperative Corporation Act could not use funds for campaign activity or engage in a ballot initiative. Nebraska Statute 49-1469, however, says that a private corporation can make a contribution and can engage in a ballot question, and we've seen opinions by the Attorney General that reaffirm this fact. As with anyone else, if a corporation engages in these activities, they would be required to file reports with the state's Accountability and Disclosure Office. I would like to make it clear that none of the NREA electric cooperative members have ever made a direct contribution to a candidate. LB 725 casts an unnecessarily wide net of limitations on electric utilities where no problem exists. The measure proposes to place restriction on public power districts that are already established in statute and proposes to limit electric cooperatives that have been good stewards of their electric ratepayer dollars and have not engaged in campaign type activities the bill seeks to eliminate. It's for these reasons that we oppose LB 725. Thank you.
Thank you for your testimony. There are questions from committee members. Senator Kavanaugh.
Thank you, Chairman. Thank you for being here, Mr. Dukeshire. Okay, so trying to wrap my mind around this. First off, you're from NREA, and we heard about NRAE, two different organizations.
Correct.
You had nothing to do with that, the AE?
Correct.
Okay, I just want to clarify. I've gotten that confused, I think, in the past. And so I want to make sure. So, okay.
We are, just to clarify for everybody, we're an association of 34 rural public power districts. The NRAE would be a PAC. That was.
And are any of those 34 rural power districts members of that PAC, or that have they contributed to that?
No.
Okay. So, I mean, one of the things you made a distinction between co-ops and public power districts, and we heard Ms. High came and said when she was in, I guess, Elkhorn Public Power District, that would qualify as a power district, not a co-op.
Correct. Right? That's a public power district and one of my members.
But for co-ops, are any of your members the co-ops as well?
Yes, we have 9 cooperative members, 3 headquartered in the state.
So for co-ops, how is a customer's experience different from a customer of a public power district?
I think from a customer's perspective, 99% of what they would see would be the same. It's their electric utility. They're getting a bill each month. Public Power District, it's a little bit different on how their board members are selected. They're selected on the ballot, whereas a cooperative member owner has an annual meeting, and you pick your board members at the annual meeting.
So, and every ratepayer can attend that annual meeting,
Correct.
and they have to attend in person to vote for the board then?
I believe so.
And if you are in one of those 9 co-ops, can you opt to receive your power from someone else, or do you have to receive power from that co-op by virtue of where you live?
No, in Nebraska, regardless of where you're getting your power from, each public power district or member cooperative has a certified service territory that they set.
So we've heard that this problem sounds like it's already been solved for public power districts, right? That the issue we're talking about here, they're not engaging in this, and you're saying it's not happening with the co-ops. But I guess my question is, from what you're telling me, is why do we have a distinction between co-ops and public power districts? Why are not the co-ops all just public power districts?
I don't know the history under why exactly some of the co-ops organize as co-ops and why public power districts. So I can't exactly speak to the history of it, but from the perspective of transparency, members are able to come to the board meetings, request information, all that. It's very similar. The culture of a rural electric cooperative would be very, very similar to that of a public power district.
Except for how they're elected, right? How the members are
And there's other differences. For example, rural electric cooperatives pay property tax. So public power districts do not.
That's an interesting distinction, because I guess my other question would be, what is the reason we shouldn't just convert all electric co-ops to public power districts, or at least hold them to the exact same standard we're holding public power districts?
I think my members would argue they although they are private corporations, they act very similarly to public power districts. And again, I think the senators would prefer that those co-ops probably continue to pay those property taxes.
I would bet that, I don't have to ask anybody, but I would imagine. So I guess why, I know you know that I have had a bill about requiring open meetings for anybody who has eminent domain. So these co-ops have power of eminent domain. They have a captive market, and they do have elected boards. So I guess but they get to be treated differently because they are a private corporation, and they're going to argue, somebody here will probably argue, if not coming up to argue it, will argue that they should not get this type of political contributions. I mean, we heard that there's an AG's opinion that says that they're allowed to do that. So I guess that there is some distinction in how they are treated, but it doesn't seem necessary other than the desire to capture property taxes, I guess.
I guess I don't understand the question exactly there.
Well, why should they be treated differently? Why should they be given these exceptions and treated differently than public power districts?
Just because of the sheer fact that they are private companies and organized as such.
Thank you.
Senator Jacobson.
Thank you, Chairman Bosselman, and thank you for being here. I think, just as a follow-up to Senator Kavanaugh's questions, correct me if I'm wrong, but my understanding is that the cooperatives, they actually have owners. The individual cooperative members are actually owners. I would assume under that structure, they also may be getting tax pass-throughs, depreciation, other issues, and they may have patronage dividend distributions and that kind of thing that isn't necessarily happening in your public power districts.
Correct. That's right.
As well as the fact that then because of that, they're not public. So therefore they're private, paying taxes because they're private, but they also have the ability to get distributions, patronage, so to speak, patronage refunds or patronage distributions because they're actually the ratepayers are the owners, literally owners from the standpoint of equity owners as well.
Right. Correct.
Much like any other farmer cooperative.
Capital credits.
Yes, correct. And that was a question. You said yes.
Seeing no other questions, thank you for your testimony. Next opponent. afternoon.
Good afternoon, Chairman Bostman, members of the committee. My name is Adam Feeser, Adamfeser. I am the Director of Cooperative Advancement for the Nebraska Cooperative Council. The council represents the interests of nearly all Nebraska's agricultural cooperatives and several rural electric and telephone cooperatives as well. The rural electric cooperatives that are members of the council include Midwest Electric Cooperative Corporation in Grant, Nebraska, Panhandle Rural Electric Members Association in Alliance, Nebraska, and Niobrara Rural Electric Association in O'Neill, Nebraska. We appear today in opposition to LB 725. Nebraska's rural electric cooperatives are not public power districts. They are not political subdivisions of the state. They are not subject to the board election procedures of state, nor are their proceeds from the sale of electricity considered in any manner to be public funds. The member users of rural electric cooperatives cover costs of construction and maintenance of the electric infrastructure and maintain capital credits or financial interest in the assets of the cooperative that are eventually redeemed to the member. None of the proceeds received by rural electric cooperative for the sale of electricity are considered public funds. This was written without the amendment, as a lot of the other things. So the next hefty paragraph is about the definition of ratepayer. Address that, see that language. I won't say about that, I don't think. Clearly, one of LB 725's primary goals is to restrict private rural electric cooperatives formed under the Electric Cooperative Corporation Act, which are privately held cooperative corporations owned by their member users, from participating directly or indirectly in candidate race or ballot question. And it creates a criminal penalty for doing so. I believe I heard that that's actually a civil penalty under the amendment. Again, this was written before then. This is true even though the Accountability and Disclosure Act, opinions of the Nebraska Attorney General, and settled law allow privately held corporations in Nebraska to make contributions to candidate committees and engage in ballot questions. There are many privately held utility corporations serving Nebraska's utility needs. The city of Lincoln and many rural communities contract with one privately held natural gas provider that is paid for providing such service fee. The same is true in many rural communities that provide only one source of telephone, internet, or other telecommunications service. While LB 725 seeks to prohibit rural electric cooperatives from directly or indirectly participating in candidate elections and ballot question elections, these other privately held entities, many of whom have their own political action committees, are not likewise restricted. It is our opinion that singling out rural electric cooperatives in LB 725 raises serious free speech and equal protection constitutional questions. For the foregoing reasons, we urge the committee to not send LB 725 to the floor of the legislature. I will say right now, I'm relatively new to the Cooperative Council, about 6 months in. Rocky Weber, our president of legal counsel, normally would be here, but he's out sick today. So if we have a lot of technical questions, I may just have to say, get back to you. I'll try my best. And he's sick, but he's still been texting me because he can't help himself. But I will try my best to answer on your questions. I think Senator Moser had a question about co-op members, their boards being elected by their members, and their members can also recall their board. I did want to clarify that. Differences include, member ownership. I think that's been addressed, and that members can also earn capital through the cooperative. But if you have a lot of questions, I might have to refer you to Rocky.
Okay, thank you for your testimony, Sir Jacobson.
Thank you, Chairman Bostman. Thank you, Mr. Feeser, for being here, and I'll try to be very light softball question, hopefully, for this.
Perfect.
It's more curiosity. Very familiar with, of course, Nebraska Public Power, and then all of the, Dawson Public and all of the other public power companies that have sections of the state territory, so to speak, that they control. So where do the power cooperatives fit in? Do they fit in around those other public power districts so that there's not overlap, so that you own the infrastructure that's carrying the power in those areas, or is there some overlap in territory?
I actually think our previous testimony probably did a good job answering this, where it seemed like there were territories that are divided up amongst the public power districts and the cooperatives. But if I'm wrong in that, we can hopefully address it maybe on the next bill.
Gotcha. But I think, if I'm not mistaken, I know they've got separate territories. I know where Dawson comes up against North Platte, and Municipal Light and Water has their own power within the city limits of North Platte, and Dawson is around North Platte. So and they're responsible, municipal light and water is responsible for their infrastructure, Dawson's responsible for their infrastructure. I'm assuming the cooperatives work very similar like a municipal light and water would in North Platte, where you're going to have territories where your members are going to, the members of those cooperatives are going to own that infrastructure.
Yeah.
And then they would still be, for the most part, then they'd be basically the exclusive provider for power, unless you're going to produce your own.
That's my understanding as well. And if I'm wrong, I'm sure I'll be receiving a text right now, probably.
Perfect. We'll have an opportunity on the reps around here. So thank you for your testimony.
Appreciate it, Senator Jacobson.
Seeing no other questions, thank you for your testimony. Next opponent. Does anyone else like to testify in opposition to LB 725? Anyone like to testify in the neutral capacity on LB 725? Good afternoon.
Senator Bossman, members of the committee. My name is Tim Texel, TIM, last name is TEXEL. I'm the Executive Director and General Counsel for the Nebraska Power Review Board. I did not plan on testifying on this bill, and my board didn't authorize me to come in. I wanted to simply address Senator Jacobson's question on the service territories. And yes, for purposes of the service territories that the Power Review Board oversees, the cooperatives have service territories just like the public power districts. So in that respect, they both have retail set service area territories where they're essentially monopoly. So I just wanted to clarify that point. So Rocky, I believe it was, doesn't have to get back with you on it. So unless there's any other questions for me to clarify, that's all I wanted to point out.
Sir Kavanaugh.
Yes.
Thank you, Chairman. Thanks for being here, Mr. Texel. So just to clarify, no one in the state can choose who their provider is.
At the retail level, it depends who's right. Essentially, you're in somebody's service territory and that utility has the right to serve you. And you can't choose to necessarily go to another one. The utilities can trade customers or allow somebody to serve them in their territory, but the customer can't say, I'm insisting to be served by the other entity.
When you say the utilities can trade customers, what does that mean?
Well, the utilities could say, NPPD could say there's somebody in our territory, but we'll let our neighboring utilities serve them. So even though they're in NPPD's territory, they could say that's an exception to the service territory and will allow you to serve them in there. So they can they could trade two customers and say, we'll take this one, you take that one. And it's an exception to the normal service area rule. So even though you're in NPPD's territory, it changes the normal rule, so to speak.
How does that come about? Does the customer ask to be switched, or does
the customer can, and sometimes they call me about doing that, and I have to tell them unless the utilities agree, the only way is to file, if the other utility will file a formal request with the Power Review Board to do that against the other utilities' wishes, and then the utility has to show they want to take over the customer and the current utility cannot or will not provide adequate or reliable service. So it's very difficult to do that if they're on the other side of the service territory. The customer cannot say, I'm going to be switched. They can ask, but really it's the two utilities that have to agree. It's the customer's influence on the utilities that would maybe change it, not their legal right to demand it.
Thank you.
Other questions? Seeing none, thank you for your testimony.
Thank you.
Any other to testify in neutral capacity? Anyone else in the neutral capacity? Seeing none, Senator Dungan, you're welcome to close. There are 4 proponent and 1 opponent letters received by the committee on LB 725.
Thank you again, Chair Bostelman, and thank you, members of the committee. I don't want to take too much time, but I do want to try to address some of the issues that were brought up, and I can talk to Senator Jacobson more about these too in detail, but these are going to go somewhat in chronological order because that's how I was taking notes. To Senator Jacobson's issue about sort of the concern of collateral consequences, doesn't want to have an issue where somebody supports somebody and inadvertently gets in trouble for it. I want to be very clear that the intention behind this bill is to limit the use of ratepayer proceeds. So notwithstanding any other prohibitions that I'm not entirely sure about, they could say, you know, we support this issue generally speaking, but they just can't use ratepayer proceeds for that. They can't pay for an ad. They can't give a donation. It doesn't prohibit their speech. And so I think that's an important thing to point out. In addition to that, this also doesn't prohibit that. What I'm trying to say here is this doesn't necessarily prohibit a co-op from creating maybe a separate arm or a separate branch like a PAC, like we've talked about, and then utilizing that PAC for donations so long as nothing they're using are ratepayer proceeds. So they could start like a whole separate entity and say, we're going to utilize this to support X, Y, and Z. But in order to do so, they would just have to document where that money's coming from, donations, things like that, which when we get to my next bill, we can talk about how important it is to document those things. But they can utilize money so long as it's not ratepayer proceeds. So I think that's important to note. In addition to that, some of the testimony we heard from NPPD, which I, again, really appreciate them coming and talking to me along with other stakeholders. I apologize for not getting them the amendment earlier. I just got a copy of it here ready today, so I'll make sure they get a copy of that. They rightfully point out that the public power districts are currently prohibited from participating in electioneering or in any way, shape, or form supporting a candidate or a committee. But what we're trying to do here is close a loophole. So they may not be able to actively participate in that. But what we're trying to prevent here is them taking ratepayer proceeds and maybe unintentionally providing them to another entity who then utilizes those ratepayer proceeds for those things that we're trying to prohibit. So I don't think this is duplicative. I don't think this is redundant. It addresses a separate and apart issue from whether or not public power entities can donate direct funds. And that's why we brought this in the first place. Senator Slama, to your points too, and I think this was an issue that was brought up to me by LES and a number of other individuals. What we don't want to do here is say employees of an entity now can't participate in elections. That would be, I think, very problematic and probably unconstitutional. We don't want to do that. I am happy to look at language that would clarify that that's not in any way, shape, or form our intention. However, as it's currently written under the AM 586, on line 10, it defines ratepayer proceeds, which I believe Senator Kavanaugh was talking about. But then the actual prohibition here is on line 12. Subparagraph 2, a district or corporation organized under Chapter 70 shall not. And so what we're talking about here is the district or the corporation using ratepayer proceeds for the purpose of campaigning. Yes, under the penalty provision on line 23, we mentioned any officer, employee, or agent can be subject to that civil penalty. But the actual prohibition on line 12 is for a district or a corporation. So that's the entity we're talking about. I believe a plain reading of that statute or the proposed language for the statute doesn't prohibit an individual in their own capacity as an employee from donating to anything. Again, that was not our intention. I think a plain reading of the statute doesn't prohibit that, but if clarifying language were necessary in order to ensure that employees of public power districts or co-ops could, with their compensation for their employment, do with it as they please, however you wanted to word that, we'd be open to that, because the last thing I want to do is try to limit somebody's free speech as an individual. Our main concern, as I said before, is ensuring that ratepayer proceeds are not improperly used, are not maliciously used, or even unintentionally used through some sort of pass-through entity to influence elections. As I said in my opening, I'm more than happy to talk to more of the stakeholders involved and have these conversations. I'm willing to talk about how we can make it better, but the intent behind this is simply to protect captive audiences and ratepayers from having their money used in elections they may not agree with. With that, I would urge your consideration of 725, and I'm happy to answer any final questions you might have.
Any other questions by committee members? Seeing none, that will close our hearing, LB 725. Senator Dungan, you are welcome to open on LB 726.
Thank you. Good afternoon again, Chair Bostelman and members of the Natural Resources Committee. I am Senator George Dungan, Georgedungan. I represent the good people of Northeast Lincoln in Legislative District 26. Today, I'm introducing LB 726. We hear a lot about transparency these days. It's clear that Nebraskans want to be educated and well-informed about issues that are important to them. More specifically, we all care about our electrical utilities. We turn off the lights when we leave a room. We worry about power outages during severe weather. We rely on electricity as an integral part of our modern lives. And yet, I have a concern that there's a lack of transparency about how certain companies or power companies are operating. LB 726 presents an opportunity to increase transparency about electric utilities. If passed, this bill would require electric utility companies to provide ratepayers with a public-facing website with the following information. 1, board meeting dates, times, and locations at least 10 days before the date of the meeting. 2, board meeting agendas at least 10 days in advance. 3, board meeting minutes published no later than 10 days after the meeting. 4, current rate schedules, fees, rents, and other charges made or levied by the board. 5, a full and complete statement showing receipts and disbursements of the electric utility. 6, fiscal year budget. 7, service territories. When applicable, the Power Review Board has a map to link for this. 8, a list of all current board members. 9, board member district and sub-district boundaries, if applicable, published as a map in writing. 10, ways to contact board members. And finally, 11, ways to contact electric utility staff. This transparency is crucial because Nebraska's electrical utilities are public provided, regulated, and operated. They have no choice but to remain customers of the utilities. We cannot conduct our lives without them, and so therefore we believe it's only that ratepayers be aware of how these utilities operate. In fostering transparency, we as ratepayers would have a clear idea of what our money is going to. Electrical utilities should not only be responsible for keeping the lights on at home, but also for shining a light on their operation. Your consider questions you might have about LB 726.
Questions from committee members? Senator Jacobson.
Thank you, Chairman Bostelman and Senator Dungan. I don't always turn off the lights when I go out of the room.
Neither do I, and I get in trouble for it on a
My
regular
wife
basis.
reminds me of that all the time. So just for the record. But I guess my biggest concern when I first read the bill was I'm a banker, and I think about the disclosures that we dump out and the number of trees we kill to just do disclosures which end up in the wastebasket and then get recycled because nobody cares. And I guess what I'm trying to figure out is that since this is an exclusive, you can't buy from anyone else, so you're going to buy from here. Why is all this information necessary, and why can't this be available to those who ask for it, as opposed to every time it seems like you get something that's required and you miss something or something changes, or I just get really nervous about all of these unfunded mandates that are going out that end up can be gotchas along the way. And so I can tell you, as a businessman and particularly as a banker who deals with regulation all the time, enough already on the regulation, particularly when I start thinking about, and particularly when I get into, and I'm guessing there'll be some testifiers behind you that are probably going to be opposed to this. When you start looking at all of the receipts and expenditures, wow. I'm trying to figure out are you hearing from people that this is a problem, and what are they trying to glean from this with all this sunshine or sunlight, if you will, or light spotted on it, shine on it?
That's a really good question. So first of all, I think one of the major differences that I guess I would point out or say about banking regulation, maybe some other corporate regulation versus governmental regulation, is, as we've already indicated, because we're a public power state, we are sort of a captive audience in a certain way. And I want to be very clear. I love that we're a public power state, and I support that. That being said, when there is a overarchingly public entity that's responsible for something as integral as electricity, I think accountability is important. You're right. It's not like we can get that information and then turn around and say, well, I'm going to go with the other person now. And I think that's a well-taken point. However, to me, it's not about consumer information in an effort to direct purchasing power. It's about consumer information that can then later on affect things like elections. And you mentioned in our last hearing that we have these elections. I think Senator Mosier might have brought that up too. And accountability when it comes to public power oftentimes is evident in those elections. And so this information is important because I think it holds these entities accountable in such a way that it allows folks in the world to know what's going on and then make decisions down the road when it comes to elections and things like that based on the information. I believe that a vast number of our public power entities are currently doing a lot of this, not all of it. Based on a basic review that we had looking at all electrical utilities, including co-ops, who would be involved in this as well. For example, 92% currently have on websites that their board of directors names. 77% have notice of board meeting dates. Only 62% have the location of those meeting dates, and only 56% have the time of the meeting dates. You go down the line a little bit more, only 26% currently provide financial information. Only 18% have board of director district boundaries, and then getting even lower, 3% of the electrical utilities that we looked at, of all of them across the board, have districts as described in their charter. So as you kind of go down the line there, you see diminishment in the information being provided. And to your point, and I've talked with other stakeholders about this, a lot of that information would be available if somebody were to go in and ask for it. I think when you start to talk about the difficulties, whether it's geographic or time-wise that go into that, it can have a chilling effect on the desire to get that information. So let's say somebody wakes up and says, I really do genuinely want to know what the board director district boundaries are. And only 18% of websites have that information. When they start thinking about, well, am I going to take time off work to go in and figure that out and talk to this person? It can have this diminishing effect on whether or not they're actually going to get that information. Whereas if all of that is provided on the website, they can log on, they can take a look at that, have that information, and do with it what they will. And so, again, I think the vast majority of our electrical entities are currently abiding by a lot of these things, but not all of them. And I believe that these are all things that the public should have a right to know, given that they are not getting that choice of entities. And so if they are going to be that quote unquote captive audience, I think they are entitled to that transparency and that information because they can make better decisions based on it.
Thank you.
Senator Hughes.
Okay, thank you, Chairman. Thank you, George. I said George, Senator Dungan, sorry. We're roommates, so, you know, anyway. So you kind of answered it with you went through the 90% on meeting dates. Because one of the things I did when I was campaigning, I've got 4 rural public power in my area, in my district. And one of the first things I did was I pulled each of the websites up because I emailed them. I wanted to come to one of their board meetings. Every single one of them had the board. Usually they're like a set date. It's the second Friday of the month or whatever. They had all the board members listed, ways to contact, had areas that some of them were just Polk County. Well, that's pretty obvious. It's Polk County. So I guess I'm a little bit curious why this would need to happen. Another thing, I came from a school board, right? And one of my biggest things, and there's a bill out right now, a constitutional amendment for unfunded mandates. And I feel like this might be, and maybe it wouldn't be that big deal to have this stuff, but I just hate putting more things on a public entity to do that ultimately is going to cost more money, which then costs me more money. You know, on a school board, it's property tax, right? You need to put stuff on the website. So that's a person that's not teaching that. So then my property tax goes up. In this case, it would be my electric rate goes up because now I'm paying, and it might be minor, but it adds up all the financial things and stuff. So I don't know. I'm just wondering if it's something that, hey, we highly suggest, we just go around and say, hey guys, why don't you throw up a little bit more information that's easy to do? And I don't know. I'm not understanding why this needs to be legislated maybe. So can you answer that, please? Sorry, I talked way too much there.
No, I am often accused of talking too much as well, so I know how it feels. I think that, again, your point is well taken. I understand that it could be potentially burdensome for certain individuals. The intention is not to give an unfunded mandate to an organization where they then have to pass on that cost to anybody else. The fiscal note shows no impact, and so I think that's worth noting here as well. But in addition to that, I just think that in a world where we all agree, generally speaking, that transparency is important, it shouldn't be so much to ask for this information. I guess not to you, but I just in general, I think reject the notion that this is overly burdensome when I, as a ratepayer, may have questions about this and may have a difficult time finding out these answers. And again, I think that I run into that maybe less here in Lincoln than other places maybe do. But at the end of the day, if anybody wants any of this information, I don't think it's too much to ask that we know what the meeting's minutes were or what the agenda is for the upcoming meeting and those kind of things, because I think those are important. And I think it's important that people have the opportunity to participate in a lot of these things and be able to attend these meetings, make public comment on a lot of what's going on. And I just have concerns when we went through and did the research and looked at how few entities, electrical utilities, are currently providing all of this information. So I guess I get the concern that it might be a lot, but to me, it's worth it, just given the fact that these are important things for people to know. And I also can't say why somebody might want to know all of these things. It's different for everyone. But if somebody wants this information from their public utility, I think they should be able to get it, because that's a public utility's job, is to provide information and provide power and utilities for the people they serve. And so that's kind of what I would hope it would serve.
So then you just kind of led me to, so did you have someone come to you and say, hey, I called them and they wouldn't give me this information? Or I mean, where did this, what made you bring this back?
I mean, it came from a number of different things, but I think at the end of the day, it was mainly based on the fact that talking to folks who have looked into this and done this research, I was very surprised at how few entities provided some of this information, and I thought that should be fixed, because I'm a general supporter and proponent of transparency, sunshine laws, things like that. I think it's very helpful. So it came from finding out some of the issues here and saying there's got to be something we can do to fix that.
Cool. Thank you.
So I'm glad to hear that on the transparency side, you're in favor of that. You list on here, you have board members who are currently serving. What about board members who are serving, have a business selling power to that utility?
So disclosing as a factor on here, board members who have power that's getting sold to
Well, I
that?
mean, should that be disclosed? Should that be, let the ratepayers know that, hey, or they're a lobbyist?
I mean, I would definitely.
And to be fair, you may not know, those do exist today and have exist on public power boards.
Mhm.
So today, on a public power board, there's a board member who owns a company and sells power to a public power district. And so, also there's two lobbyists that served on a public power district board that affected that public power district, the board, and how that voted. So I guess my question is we're talking transparency, and I'm glad that you agree there, that full disclosure on this should also be perhaps included, that they're doing business with that utility or that whoever it is, the public power district, the co-op, or whichever it may be.
Yeah, I mean, I think in the name of transparency, I'd be more than happy to talk about what all could be included, but I do think it's important that we get a lot of this across the finish line here to make sure the public has access to that.
Okay, appreciate it. Mr. Kavanaugh.
Thank you, Chairman Oswald. I like that question, Chairman. And so I'm pretty sure that the NPPD, OPPD members have to fill out C1 forms. Maybe would you entertain requiring that they include C1 forms on the website as well? Because I think that would be captured if somebody was in that particular business or whatever their business is, probably have to be disclosed on a C1.
I would definitely, I know they do have to fill those out, and I would definitely entertain the idea of adding that on as a requirement here as well.
Do you think it'd be appropriate to add the requirement of a C1 form to all electric generators then, if we're going to require the public power utilities to do that?
I mean, I think it'd be only fair.
Thank you.
Sir Mosier.
Well, looking at the bill, I'm kind of wondering what the purpose of it is. I mean, yes, transparency is important, but most of this information can be figured out to some level just on your own. So it might be kind of redundant in requiring them to put it on their website. I mean, the power districts have to show who they bought things from, all their disbursements, I think, are public records. And then after I got all that information, I can't buy power from somebody else because of it. I mean, and most people scramble just to keep their lives together, kind of week to week. Anyway, it would have to take a real activist to want this information. And then if it's still available, you know, why not just let them, those few that would really use it, let them develop this information on their own and do with it what, you know, they think they want to do.
Yeah, I mean, I think that if that information is already readily available, if they do in fact have it, it's just my opinion that it wouldn't be that hard to put on the website. I've spoken with LES and some other folks about whether or not it would be onerous or burdensome to do that. But I genuinely think that if they already have a lot of this information, we're not asking a lot to make it public. And if anybody does want this information, I guess I just don't think they should have to jump through a bunch of hoops to get it, especially if it's a public power entity that we're paying ratepayer rates to.
But I think you're creating extra expense for them that's going to be paid by all ratepayers.
And I don't have any number on that. Again, the fiscal note that I saw here was zero for us, obviously. I've not heard any hard data of what that money would be. I know there's been concerns brought to me by stakeholders about what the cost might be for hiring a new person to gather this information and post it all. Having talked to individuals in, again, stakeholders, I just have a hard time believing they don't already have enough people that could do this. I think there's tons of people that could very easily add this information to the website. Like you said, this information already exists and they already have it. And so the small little step of adding it to the website, I don't feel like would have a major effect on raising costs to all ratepayers, but I'd have to get the actual numbers on that because it's not presented to me.
Thank you.
Other issues? Thank you. All right. Who would like to test support of LB 726, please step forward.
There's I can give you a few more of these, but I think you would have a copy of this because it's the same. And I've been listening. I'll just start here. Good afternoon again. My name's Kate High, Katehigh, and I'm here in support of LB 726. And I've been listening to the discussion up here, and I think I need to do a point of clarification in regard to the complaint that I filed. This is my understanding from reading a lot on websites about the history of Nebraska electric generation and transmission. 20 rural public power districts, that one of which was the Elkhorn Rural Public Power District, back in the 1950s, went together, and these 20 rural public power districts created a co-op. So the members of the co-op are these 20 rural public power districts. And the reason they created this co-op is that they could buy electricity cheaper. They could buy bigger volumes of it, got a bigger deal, so that they got a better price for it. And they also used it to get money to build transmission lines because, it's pretty hard, from one little rural public to another. So that just made sense. So the way that the co-op, this particular co-op was set up, there was 20 members, and I believe there was one private one on the side. They took somebody from their board of directors, which were publicly elected, and they all sit on the board of this co-op, and they make all these decisions. So there's money that comes from all of these co-op, rural public power districts, pay into this co-op for these two specific reasons: electric transmission lines and to buy electricity cheaper. That's the purpose of the co-op. And they bring their bag of money with them, and they have a representative that sits on the board, and they make the decisions. So this sounds a little bit different than the double circle co-op down the block, where you might buy other things. This is a very specific kind of co-op that serves that. So I got interested in this because I do money and politics research, and I found out about this $7,500 donation. It was kind of popping up in some other research, and it was tracking me back. So I wanted to go find out how this NRA PAC got formed out of this electric co-op. So I went to that website, which is, they got a lot of stuff on there, not too, but it's there. And I wondered who made the motion that approved the PAC? Because the person who is the executive director and other people that were employees of the NEGT were the founders, the creators, the treasurer, that had people who their names are on when the NRA PAC was formed. The NRA PAC cohabits, has exactly the same address as NEGT. And there's overlap of the officers in this. So I was interested in knowing who made the motion that put this in place, that says NRA can have their offices here and they can have some money. So who did that? Where is it in the minutes? Who made that motion? Who voted for it? So there was that. Then who okayed the $7,500 to put into that PAC? Was there some discussion about it? Did everybody say, oh yeah, go ahead, put $7,500 in it? We just don't know. So I'm kind of feeling like maybe what we need is something there that we can hold people accountable for. Because if I would have been living up in Madison County at that time, I sure want to know if that was my guy that was voting for that PAC. Because when it comes election time, that's going to be a point that I need to know when I'm going to the polls and vote. So I feel like I should have that as a citizen, as a ratepayer, and as a person who's interested in good governance. I just wanted to clear that up because that's my main point. I really think we all feel the same way, that when, for 9/10 of the time, you see all that stuff out on a website and who cares? But when I wanted to go actually find something, like where's the minutes of the meeting, who authorizes this payment, I think I should have a right to know that. But now, because it's a co-op, it gets this special status as a co-op, and now it's a corporation. I think that's why we need this bill that says, let's not play two legalese here. This is public money that's just getting tracked through different entities, but it's still public money, and it's still being, the members of the co-op are actually elected officials, and they're managing this money. And I think we need to follow it through, and let's say, do we want public money? It's against the law in Nebraska to use public money for political purposes. And let's just keep that consistent across the board. So thank you very much. I appreciate your time.
Thank you for your testimony. Hold on a second. Are there any questions? Sir Kavanaugh.
Thank you, Chairman. Thank you for being here, Ms. High, and thanks for that context. So are you saying that this NEGT has members, all of its members are public power districts and not electric co-ops?
No, they're the members that make up the NEGT are all individual rural public power districts. And there's one private one off the side, and I can't remember, but there's like 20 of them.
So for just the kind of the discussion we've been having here, there's two sections of statute, one that governs, I don't remember the number offhand, but that governs public electric districts. And there's a different section with different obligations and requirements for electric co-ops.
Yes, I do believe there's a special notations, and that's in 704. That's kind of in that area. That has to do with electric co-ops, I do believe.
And so, and I'm just trying to make sure we're on the same page of this conversation. So the entities that are parts of this NEGT are actually under the section of the statute that applies to public power districts and not electric co-ops or not.
Right. So the members that make up the co-op aren't co-ops themselves.
Okay. And so we heard, I think, at least Mr. McClure's testimony, it says public power districts are explicitly already prohibited from putting money into political campaigns.
Right.
Okay. And so what you're saying is that the $7,500 that we've talked about, and I know I've heard about it at other hearings as well, was money that came from not co-ops to a co-op, but from public power districts to a co-op, and then to
It was a co-op that was founded by and funded by public power districts going together and pooling their money so they get a better deal on electric buys.
And so your interest in this bill is you think that if you were able to look at that information, that would inform your decision-making about elections of your public power district board.
Yeah, well, that was what I was looking for. I mean, that's, and I think voters like that kind of information when you go to the polls and who are these people? Where I lived, it would be whether you're an Olson or a Hanson. But So you need, so yeah, that's becoming an informed voter. And I think voters and ratepayers, that's an important consideration for them. I know that it would have been a consideration for me.
Do you think that also publicizing these sort of conduct or all conduct would have a chilling effect on shenanigans, which is what this sounds like?
Well, yes, a little disinfectant, the sunshine. I don't know if it would cool that down, but I think that holding your actions accountable is an important part of governance, is that not to try to just, keep it away from people and not disclose it. And I would say 9/10 of the time, nobody cares, but sometimes it does make a difference.
Thank you.
And as far as, killing trees, most of us now get our information online. So killing trees is not the issue that it used to be.
Well, thank you. This has been very informative.
Seeing no other questions, thank you for staying in
Thank
for
you very
testimony.
much.
Next proponent.
Good afternoon again, Senator Bosman, members of the committee. Al Davis testifying on behalf of the Nebraska chapter of Sierra Club and the Nebraska Farmers Union today. I think I want to just take the time, my testimony is pretty short anyway, I just want to take a little bit of time and just say why I think that this bill is an important tool for us, for you and for us. So if we saw this morph into websites which contain all this information that Senator Dungan's put forward. First of all, I want to say I don't think that it's going to be complicated to do that. Most of this stuff is already done. And people are putting together a PDF or something. You just load the PDF to the website, and basically that's it with the minutes and the agenda and those things. So you get into the budget piece, that maybe is a little more complicated. And, maybe that needs to be investigated, but there could be minimum requirements that the committee could put together to address some of those questions. So then what happens is you now have an overview of the different districts, and you can really compare apples to apples to see how well they're performing. Because I don't think the public has a good grasp of that. We all hope that our public power districts are performing at top levels, but I'm not sure how you evaluate that. So why do you want to know that? Well, obviously efficiency is everything in business. These are businesses. They are public businesses in many respects, but you want to have these businesses perform as efficiently as possible. And so I think openness and transparency will make them perform in a better manner. And I had suggested in my testimony that you could even do video now. Some school board members, some school board are conducting meetings through video so that people can participate more. I think anytime you have more participation from the public, you're going to have a better entity. Thank you.
Thank you for your testimony. Further questions from committee members? Seeing none, thank you for your testimony. Next proponent, please. Anyone else would like to testify in support of LB 726? Seeing none, anyone would like to testify in opposition to LB 726? Good afternoon.
Good afternoon, Chairman Bostelman, members of the committee. My name is John McClure, John, MC, capital CLURE. I'm Executive Vice President for External Affairs and General Counsel for Nebraska Public Power District. I'm here testifying today in opposition of LB 726. I'm also speaking on behalf of the Nebraska Power Association, which is comprised of the state's electric utilities, municipal electrics, public power districts, electric cooperatives, and a joint action agency. LB 726 provides redundant and conflicting requirements for public entities regarding compliance with the open meetings law. And just to look at some specific examples, on page 2 of the bill, on line 20, it talks about board meeting dates, times, locations shall be published at least 10 days before the date of the meeting. And on line 22, board meeting agendas, which shall be published at least 10 days before the date of the meeting. The open meetings law in Nebraska that applies to all public entities in section 84-1411 sub 1 sub A says that entities are required to provide reasonable advance notice. So now we're going to carve out electric entities and put a specific date on them that's different than what's in the Open Meetings Act for the entire state. I would mention that while the Open Meetings Act does require that minutes be prepared by each entity that's covered within 10 days, and we could certainly post those, but for most entities, those minutes are draft only. They're not final until the next meeting of that public entity where they're voted on, approved, corrected if necessary. In our case at NPPD, we already do most of this and much more. If you go to our website, again, we're one of the largest utilities in the state. We have the resources to do this. I'm concerned, I think you may hear from subsequent witnesses, about the impact of this on the smaller electric utilities in the state, many of which, as I mentioned, on a previous bill, those all are these are going to be imposed across the board on those cities for other activities that are taking place within the municipality. I think it will add, and I appreciate Senator Hughes' comments earlier about what kind of burden you put these folks. May not have someone extra, but every month adding all this additional information. In the case of NPPD, we have every month hundreds of expenditures that are made for various vendors for all kinds of things that we may be purchasing. Again, I would also point out the public records law already gives people access to this, and many of us are publishing much of it. I'm not aware of a hankering for this or a lack of response, and I think of an example with a report that we're required by statute to file with the Power Review Board. I was looking at some statutes one day. I saw that. I called Director Texel and asked him, Executive Director Texel, asked him about it. And I said, what do you do with it? Well, we file it. Does anybody ever ask for it? No. And so just piling work on to me doesn't seem like it's appropriate, because we already have open meetings law that sets out a lot of requirements. We have a public records law. So much is voluntarily provided. I don't think there are a number of folks that are asking for these things that aren't available already. So with that, I would urge you not to advance this bill, and also have the same concerns about the ratepayer dollar piece of this that I referenced in earlier testimony. I know that testimony's not incorporated here, but you've heard it, and I won't repeat it. I'd be happy to answer any questions.
Thank you for your testimony. Or questions from committee members? Senator Kavanaugh.
Thank you, Chairman. Thank you for being here, Mr. McClure. So on the NPPD website here, just taking a look. It's a good website. You got a lot of information here. How much does NPPD spend a month updating the website?
We have, I don't have that number. I'll see if I can find out, but we obviously are updating things with respect to our board meetings. We live stream our board meetings, then we take that video, and that's put on our website for board meetings. So if you look under Board of Directors, you will see a bio of each board member. You'll see a phone number. You will see when they were elected, the area they represent, a map of the district that they represent. You will see, again, extensive contact information. I can only speak for our utility as to what's out there. And there's all kinds of board presentations for each board meeting that you can find. And that's just on the board side.
And I appreciate that. You got a good website. But I guess here's my question. Your argument is that this is overly burdensome and unnecessary and wasteful of ratepayer money. So why is NPPD wasting money doing all of that?
I'm not saying it's wasteful. I'm saying it's a challenge, in particular, I believe, for smaller systems. We have a corporate communications department. We have people that are used to dealing with a website. We actually have provided and helped create websites for a number of our customers over the years who couldn't do it. We created a very basic website because it's important to have one. When I say customers, I'm referring to our utility customers, so a public power district or a municipality. But whether they have sufficient staff to put all this on, I can't speak for them. We can do it at NPPD, and as you've looked at this, we do it voluntarily now. I just don't think in Nebraska, we like to keep imposing new requirements from the government on entities to have to do things, unless there's a good reason.
Well, I mean, I think we had some good reasons earlier, but as I go through the list of things, I'm just trying to think through this argument that this is going to be overly burdensome and costly. So I'll just start at the back. Method by which to contact the electric utility staff. Seems like you do that, maybe you'd have to update that once a year. A method by which to contact board members. If you get a new board member, you might have to change the update, but that sounds like not a pretty regular update. Board member district, sub-district boundaries. Again, probably have to update that once every 2 years or something along those lines. A list of all board members currently serving. Again, only when there's a change. Service territory. Probably doesn't change that much, so that's not going to be a regular update. Fiscal year budget. That's probably going to be updated once a year. A full complete statement showing receipts and disbursements of electric utilities. That might be a monthly change. Current rate schedule, fees, rents, and other charges made and levied on the board. Again, that might be a monthly change. Board meeting minutes, I guess with whatever regularity cycle the board meetings are. Board meeting agenda, 10 days before. So that is probably monthly, right? Board meeting dates, times before the meeting. And so that's again monthly. So there's about 4 or 5 things out of the 11 that would need to be updated regularly. The other half of them are maybe an annual. And for the fees and schedules and budgets and those sorts of things, are those not things that are already being generated and just not posted on the website?
In our case, many of these are already, I haven't gone through and checked it item for item, but most everything here you can find on our website.
On your website?
Yes.
Right. And so I guess for all these other folks, the NPA who are opposing it, so this, from your perspective, this wouldn't change much for NPPD.
Not for what we post out there. Although there are some exceptions. There's some direct conflicts with the open meetings law, which I find troublesome, that we're singling out the electric industry and imposing different requirements on it than we're requiring of other public entities. And for many of the municipal electric utilities, and I believe there'll be a witness after me who's far more knowledgeable in this area than I am, you're putting a standard out for how they deal with their electric distribution department that's different than what they do with all their other departments.
Mm-hmm. Well, in terms of the date part, I would imagine that's probably solvable in an amendment for this bill. I would imagine Senator Dungan would consider complying with dates with the Open Meetings Act. But I guess that if these were already documents that are being generated by each one of these entities, and most of them don't require any real update, and it just would be creating a form website and uploading a link, I just have a real hard time understanding where the cost is coming in.
Again, I think the challenge, and subsequent witnesses may be able to share more, is for the folks that aren't doing this as much as we are right now.
I can stop beating up on you then.
Okay.
Other questions from committee members? Saying none, thank you for your testimony.
Thank you.
Next opponent. Good afternoon, welcome.
Thank you. Good afternoon. My name is Lash, L-A-S-H, Chaffin, C-H-A-F-F-I-N. I'm a staff member at the League of Nebraska Municipalities. And today I would like to offer the League's opposition to LB 726. And first I want to say municipal electric utilities are not opposed to transparency. As a matter of fact, if you get one of them cornered, they're going to tell you for hours about how proud they are of their electric utility. But that said, there are 120 municipal electric utilities across the state. And they range from the Grand Islands and the Fremonts and the North Plattes to places as small as Lyman and Talmadge. And they're all under the same set of laws. And then also keep in mind, in Nebraska, every municipal utility is also subject, in addition to being subject to the laws of electric utilities, they're also subject to all the laws governing public entities, Chapter 13, Chapter 84. They're also subject to all the laws governing municipalities, Chapters 15, 16, 17, 18, and 19. So there are numerous transparency laws that municipal utilities already comply with. Going through the list, everything except the service territory map for a municipal utility is already covered by a reasonable public notice statute, a required legal publication notice statute, or in some cases, a publication and hearing statute, and in one case, a legal publication, reasonable advance notice, and multiple hearing requirement. So everything on the list, there is transparency galore on all of these issues with respect to municipal utilities. And also the list, it does create an additional layer of inconsistency. It uses words and concepts that are slightly inconsistent with the existing transparency laws. For instance, it uses the term minutes. Cities use the term legal official proceedings, which is a slightly different concept that has a different series of case law that's established across the country. So in fact, that would become a duplicative. You'd have to prepare two separate and distinct documents for publication in an additional source. I could go through each one, but I think that's probably a discussion that we could have with Senator Dungan at some point, because that would take a long time. So each one has its own unique, inconsistent characteristics with current transparency laws, many of which cities pay for. When something goes in the newspaper, it doesn't go in for free. They're literally, between all the political subdivisions, millions of dollars of ratepayer and taxpayer money goes to officially required publications. And this would be on top of that. Now I guess there's a legitimate issue of do the current transparency laws in Nebraska translate to the year 2023? The answer may be no, but that's probably a much broader discussion beyond electric utilities. I think you need to involve the schools, the NRDs, the counties. I mean, there's every public entity that does publication and has reasonable advance notice requirements needs to be a part of that discussion. It's probably a little unfair to just overlay an additional website requirement on electric utilities. Also, with respect to the websites themselves, this in some cases, this would be a financial burden. 5 years ago, I think I fairly easily could have argued there are villages without websites. Not quite sure I can make that argument today. There might be one, but I don't think I want to publicly make that statement because there probably aren't. There are some without email at this point, but there are some that there's probably everybody's got at least a Facebook page or something, but I just don't know one way or the other if that's true. But that said, not every website is created equal. The small villages, if they have a website, it's not updated. It's a promotional website that says, this is where Talmadge is, please come visit us. Then people forget about it. And so it's not the same as an operational website where you could upload financial data. For instance, particularly, I think this overlaps with the broadband issue that the state is facing. If you happen to be a village where the best internet speed you can get 3 megabits per second upload, guess what? You're not going to be able to put ongoing financial information on your website. That's just not going to work. So this issue does overlap, particularly in the smaller municipalities, with other issues that the state is facing with respect to rural broadband access. But again, we're not against transparency, and if there are specific issues the senator would like to get, in addition to the existing transparency laws, we'd be more than happy to work with the senator on these. Thank you for your time.
Thank you for your testimony. Are there any questions from committee members?
Chair Kavanaugh.
Thank you, Chairman Bossman. I appreciate your pointing out about rural broadband, especially in the week when there's new episodes of Mandalorian come out, and I haven't had a chance to tweak Senator Bossman, Chairman Bossman about it yet, but just this is my opportunity to do that. So out of the 120, thank you for being here, by the way. Out of the 120, I mean, like, what's the smallest one?
Well, I think the smallest one, well, that's good. I tried to figure that out. I think the smallest one is Talmadge. Although my personal favorite small one is Lyman. So they're very enthusiastic.
Two great names.
Yeah.
What size are we talking about? Like, what's the ballpark?
50, 40, probably 20, 25 customers.
Okay. So if, Senator Dungan were to entertain an amendment to this to limit the size and say this only applies to, providers who provide over, service to over X number of people, would you have a suggestion at where to draw that line?
I could think about that. Obviously the devils are always in the details, but yeah, we would entertain at least looking at that. I hate to reserve any judgment on that concept, but it's certainly, I will say it does affect Fremont differently than it affects, Nelson.
Right. And I should probably apologize to Mr. McClure, because when I said I was having a hard time imagining how this would be a burden to someone, I was not imagining that we were talking about towns of 50 or 40 people.
Well, I will say Fremont has long had a active utility website. And over time, on there, they do this extensive, boring annual report that's not even required by law. But they do it regularly. So there would be some burdens to even the larger municipal utilities.
Rectifying or eliminating those redundancy and inconsistencies with the current reporting requirement. If Senator Dungan were to consider amendments to this that would say the 10-day notice is actually whatever the notice is,
Sure.
and that would eliminate some of that the duplicative burden, right?
We would be definitely interested in working with Senator Dungan to look at that type of language. We're not against transparency. Like I said, as a matter of fact, these city utilities, they love to tell you about their utility. They want more people to be interested in it.
Thank you.
Mr. Slama.
Thank you, Mr. Chairman. Not a question, but just a statement. Talmadge, Nebraska is in District 1. It is a wonderful, small, but mighty community.
It is. Oh, it's a classic community.
And it is very delightful. So that's just for the record. Go Talmadge.
So no other questions. Thank you for the shout out for broadband.
Thank you.
Good afternoon. Welcome.
Good afternoon, Chairman and committee members. My name is James Dukeshire, JAMES-DUKESHERER. I'm the Director of Government Relations for the Nebraska Rural Electric Association. The NREA represents 34 rural public power districts and electric cooperatives throughout the state, and we are here today in opposition to LB 726. I will just start by saying Mr. McClure, who testified on behalf of MPD and the MPA, did a great job of providing a lot of the points that I had in my testimony, so I'll try to amend what I say here today. We have a similar perspective, obviously, on our testimonies. If the goal of LB 726 is to promote transparency among Nebraska's public power districts and electric cooperatives, we already have that. As has been said, our state's public power districts are political subdivisions of the state, and they're subject to the Public Records Act, the Open Meetings Act. I say try making a request in another state to an investor-owned utility to get some of the information that's included in this bill and see what happens. Whereas in Nebraska, you can walk into any utility, public power district or electric cooperative, ask for these things, and you're going to receive it. Requiring all public power districts to include on their websites a full and complete statement showing all receipts and disbursements or all charges made and levied by the board could be problematic. Again, I'll say I know of no examples where a member of the public seeking reasonable information from NREA's member systems was denied that information. One additional point I'll make, Section 4 of the bill introduces an additional topic that hasn't been brought up yet. It says that ratepayer proceeds shall not be spent on elections. As stated in my testimony on LB 725, Public power districts are already prohibited from this type of activity, and electric cooperatives, the NREA member system and electric cooperatives do not participate in campaigning type activities. Furthermore, the definition of ratepayer proceeds is overly broad, far-reaching, far beyond the ratepayers that receive electric service. So it's for those reasons that we're opposed to the bill, and we ask you not to advance it. Thank you.
Thank you for your testimony. Questions from committee members? Seeing none. Thank you for your testimony. Next opponent.
Good afternoon, Chairman Bostelman, members of the committee. I'm Adam Fieser, ADAM FESCR, Director of Cooperative Advancement with the Nebraska Cooperative Council. I already referenced who we serve electric cooperatives in the state. We're here to appear in opposition to LB 726. It purports to have the intent of creating transparency regarding the governance and finances of electrical utilities, including privately held rural electric cooperatives created under the Nebraska Rural Electric Cooperative Act. As with LB 725, we believe LB 726 is a solution in search of a problem. As privately held cooperative corporations, our rural cooperative members are governed by articles of incorporation and bylaws setting forth governance procedures, member and board meeting requirements, and requirements for financial disclosure to their member owners. Bylaws require an annual meeting of the members for the purpose of electing directors and transaction of business coming before the membership. Special meetings of members may be called by the president, a majority of the board of directors, or by not less than 10% of all members entitled to vote. Bylaws generally require that notice of members' meetings be delivered not less than 10 days nor more than 30 days prior to the date of the meeting. Each member of a rural electric cooperative is entitled to one vote in the affairs of the cooperative. Elected by members, the bylaws of rural electric cooperatives typically provide that members may request and vote upon the removal of directors. Regarding financial reports, bylaws of the rural electric cooperatives typically require an audit by a certified public accountant of the books and financial records with resulting audit reports being made to the board of directors and independently to the members at their annual meeting. Nearly every item that LB 726 would purport to require of rural electric cooperatives are already required by their bylaws. In addition, modern websites of these rural electric cooperatives are readily accessible and contain the vast majority of information not otherwise provided to members at membership meetings and contained in the list of topics set forth in LB 726. Finally, LB 726 slips in a general prohibition for electric utility providers from spending any funds on electoral activity without definition of the specified activity, except to allow rural public power districts to conduct public elections of the directors. No similar allowance is made for accommodating the expenses of the election of directors of rural electric cooperatives. As with LB 725, we oppose restrictions on the election participation of privately held rural electric cooperatives. For the foregoing reasons, we oppose LB 726 and request that the committee not advance it to the floor of the legislature. As before, I'll try my best to answer any questions you might have.
Thank you for your testimony. Are there questions from committee members? Seeing none, thank you for your testimony. Is there any other opponents to LB 726? Any other opponents? Anyone in the neutral capacity?
Afternoon, Chairman Wasserman, members of the committee. My name is Tim Texel, TIM, last name is TEXEL. I'm the Executive Director and General Counsel for the Nebraska Power Review Board. The board is the state agency with primary jurisdiction over electric suppliers in the state of Nebraska, and the board takes no position on the overall policy of LB 726. But I am authorized to express the board's opposition to the current definition of what constitutes an electric utility in the bill. The definition of electric utility is set out in section 2, subsection 2, which is lines 7 to 8 on page 2 of the green copy, the introduced bill. And the definition of electric utility is, quote, any entity organized under Chapter 70 or a municipal electric system, close quote. Well, the Power Review Board is organized under Chapter 70, Article 10. So under the current bill, the green copy, the Power Review Board, the state regulatory agency, would be defined as an electric utility. My board has serious concerns about that because we are the regulatory agency, not a utility. I think that would be a problematic precedent to set in state law. I did contact Senator Dungan's office about this. I believe it was just an oversight. So I don't think I need to belabor the point, but it is a necessary change if the committee would put this out on the floor. Another point I would just make, a smaller point is, and it was mentioned in earlier testimony under Section 3, subsection 7 of the bill, utilities would be required to put their service territory on the utilities website. It doesn't specifically allow for links. And Senator Dungan in his introduction had mentioned you might be able to have a link to it, but the Power Review Board already has an online digital map of each utility service territory. So it shows the entire state. All of the state is part of some utility service territory, and we're the official repository for the service area maps, the retail service territory maps. So I think it would make sense for the utilities to link to our official map as opposed to put on their own map, and that would help alleviate any concerns about discrepancies between the official state agency map and the utilities maps, putting it on their website. Perhaps a minor point, but it might help to put in the bill that they could link to something like that for the service territories, particularly helpful for the villages, as was discussed, so that they wouldn't have to go to all the work of creating a map, because I know some of their staffs are very small and don't necessarily know how to do that. We have a contractor that does it for us, that prepares the map and updates it, and an annual contract. So with that, that's the 2 points that I wanted to make, and I'd be happy to take any questions.
Thank you for your testimony. Any questions? Sir Kavanaugh.
Thank you, Chairman Bossman. Thank you for being here, Mr. Trexel. That's a great suggestion. I like it. I'm sure Senator Dungan would take it about linking to the maps. I wondered about, I think Mr. McClure mentioned that he spoke with you and you have reports that nobody ever asked for.
I don't know specifically what he was referring to. It might be the budget statements. Every year, the utilities, the public power districts have to submit their fiscal statement and overall budget to us. They have to give us also copies of their annual audit. I don't recall an instance, maybe once in the last 20, 25 years, that anybody's asked for them. The utilities have to keep them available at their site too. But nobody, I'm not sure how many people outside the utilities know we have it. So it's just not something, that's why we don't put on our website. Nobody ever asks for it.
Well, that was going to be my next question. Do you think nobody asked for it because nobody knows you have it?
Could be. All I know is that they don't ask for it. I mean, the utilities have to have it too. So I assume most people who want it would go to the utility and request it, and the district would provide it to them. So maybe in the past that was different. I don't know the background of that requirement in state law. So we have it, but if it's been requested, it's been once or twice in 25 years.
And that is publicly available information anyone can request.
Anybody requested can have a copy. We don't put it on the website, but it's a public document. It's kept in our files. I think we keep it under the records retention policy for 2 years. And then we cycle them through, and we just don't have a request for them. So it's, we keep them and nobody requests them. So it's a bit of busy work, but that's my job under the statute.
Well, we hear a lot in the legislature. We ask a lot of people to do studies and provide information, and then we always hear nobody ever asked for these things. But then, I'm looking at your website. I can't figure out what information you have available on here, and so it wouldn't occur to me to ask you for it, I guess. And I'm sitting here having this conversation. So I guess that's one of the arguments for the bill is to put the information on. I know you're here neutral, but isn't the argument to put it out there so people don't know what they're looking for? And if they come across it, they say, oh, this is available information to me. Maybe I would like this, as opposed to putting that hurdle there where you have to know what to ask for to get information.
That's a policy decision for the legislature. I mean, I guess the one concern I have is how much information do you put on a website that people need to sift through, because the more you have on there, the more difficult it is to find any individual thing. I put on our website the things that the people request most often. Certainly the service area maps has been a huge help to a lot of entities and the public and developers. Everybody seems to love that. Anything that I get a lot of requests for, I try to make it available on our website. We have other documents that I don't put on there, and that's my response always is nobody really asks for them. We could make them available. We don't make the charters available for districts either. I could, but we don't get requests for those other than by the utilities. So I'm certainly open to doing more, but I don't see the public demand for them. If the legislature liked me to and believes people would stumble across them, I could certainly do that, make them available.
Thank you.
Seeing no other questions, thank you for your testimony.
Thank you.
Next, neutral testifier. Anyone else like to testify in the neutral capacity? Seeing none, Senator Dungan, you're welcome to close. There are 4 proponent and 1 opponent letters on LB 726.
Thank you, Chair Bostelman, and thank you, members of the committee. Just to touch on a couple of points that were brought up during the testimony, with regards to the concerns about the discrepancies between the Public Meetings Act, the Open Meetings Act, and what was in the bill, I'm more than happy to work on amendments for that. I believe Senator Kavanaugh opened up a number of amendments that I'd be open to with his questions. And it's true. I would be very open to discussing with the entities involved here ways to make this congruent or at least in line with a number of those other obligations. To the point, though, of why I think maybe we should impose a slightly more onerous burden to a certain extent on these companies versus other things that are subject to the Open Meetings Act is that a number of things are subject to the Open Meetings Act that don't deal with the massive amounts of money and the massive amounts of public dollars that go through public entities. Handle different things than power organs. And so I do think that not everything is the same, and not all things should be necessarily considered equal just because they're subject to the Open Meetings Act. But if there are actual times and dates and things that we can fix in this bill to make it align with more than I just would highlight again my concern. This is about transparency. More information is always better than less. I think Senator Kavanaugh, again, made a good point when he said a lot of times people may not know what they're missing if they don't know that it's even out there. I think that's a point very well taken. And I also don't think that we as a government should necessarily just be in the business of providing information that we think is maybe the most popular, the most asked about. We put books in libraries for a reason, and it's because we don't know what people are going to want. They're going to go find the stuff they're interested in, and far be it from us to tell them what that is. If every public library just had the New York Times top 40 bestseller list, that might be a problem because we don't know what information people are looking for. I can't sit here today and say why somebody might want all of this information, but you did hear specifically from a testifier who said, I was looking for these things and I couldn't necessarily find them. And in the circumstance that was outlined at the prior hearing with regard to the NEGT money and the way that money is being spent, that's information that perhaps would have been maybe a little bit more easy to find or more easily obtainable if this information was public. The last thing I want to do is put too hard of a burden on small entities like we talked about with towns of 50 or something like that. More than open to talking about thresholds, but at the end of the day, I just think it's important to provide more information than less. So we'd be happy to work with the committee and to work with any other stakeholders on how to improve this. And I appreciate everyone who came in and testified both in favor of and opposed to the legislation. I think it was very informative, and I'm happy to continue to talk to stakeholders in this circumstance.
Thank you. Are there any questions from the committee members? Seeing none, I will close our hearing on LB 726. Thank you all for coming. We are going to go into an exec session, so please clear the room. Yeah, committee will take a 5-minute break.